Shri Bhupendra Yadav ji.
Finance Minister to think of a special status for Andhra Pradesh.
Sir, the present amendment in enforcement and security interest and prevention of debt is the another step of economic reforms by the present government to facilitate the ease of doing business. The present bill is examined by the Joint Select Committee of Parliament, and being the chairman of that committee, I thanks to all of my colleagues who deliberated very widely in the committee, and we are able to suggest the 21 amendments in the bill. And I also thanks to the government who accepted it. And today, our country is creating an environment to encourage entrepreneurship in our country for better economic growth. Ease to doing business with easy process to start business goes through getting credit which can be simple while giving protection to investor, an effective process of enforcement of contract, and ensures easy procedure in resolving the insolvency. When the present government is coming in the power, it is fact that the financial institution in our country were suffering due to the NPA. And the present position is that 70,000 cases pending in the DRT with the 5 lakh crore rupees of the NPAs, and these bad loans are very much badly affected to our economy. The government realized this fact and started identifying the existing problem in the system. The government recognized the importance of regulatory environment in promoting entrepreneurship and undertook the objective to make India as one of the easiest places to do business. Undoubtedly and visibly, there was a scope of improvement for achieving this target. Therefore, the government working towards it. And we saw the last week the GST bill was passed. Before that, the Insolvency and Bankruptcy bill was passed. The Benami Property Act bill was passed. These were the steps which taken by the government for the economic reforms in our country. And sir, I want to say that the presently one of the biggest problem of NPA and bad loan, for that purpose to resolve this issue, the SARFAESI Act, the present SARFAESI Act, empower the secured creditor to take possession of the assets against which loans were taken in case of payment default. It is supposed to ensure fast recovery of bad loans which affects the credit market in the country. Sir, the present bill made a provision for the timely disposal of cases. Earlier we saw that the CMM have taken so much time for the recovery of the certificate. In the present bill, we are providing a limit of 30 days. This bill also proposed to create a central database to record it is to be maintained so that the information is not lost in the plethora of the intra-state report. Sir, the present amended SARFAESI Act empower the RBI to conduct audit and inspection of the asset reconstruction company. We know that the bad NPS purchased by the ARCs. So it is very necessary to create a mechanism for the regulation of ARCs. For that purpose, the ARCs buys the NPS from bank and discount and recover the money. It may be penalize the non-compelling companies. RBI, we are giving a power to RBI that RBI can also examine the statements and information of ARCs as well. RBI also allowing banks to absorb their return of asset in the staggered manner would help them in restoring the balance sheet of the normal health. Sir, the present bill also empower the DRT in light of the Supreme Court judgment. Recently, the Supreme Court given a judgment regarding the tenancy, whether the third-party tenancy right be decided by the DRT or not. Sometimes we know that the secured creditor, when the recovery process is started against the secured creditor, they immediately create a tenancy. For that purpose, sometimes the recovery was also be delays. For that purpose, in the present act, we are providing a mechanism also. Then there is also one question that where is the place of cause of action also. So we are giving to the debt recovery also a time-bound procedure. The bill also makes provision for restoring possession of secured asset to any aggrieved party in the action of the bank is invalid. We amended the provision of the DRT that can decide the third party right, including the tenancy and leasehold right in the secured asset. The present bill had changes in the jurisdiction also. In section 17, now the bank and the financial institution can file a cases within a local limit of the bank, which maintain the record of the loan. It is one of the good steps to reduce time of disposal, as the record verification, etc., used to give the reason to adjournment. Bill also provide for certain procedure which are to be done electronically, which will save the time and money. It will also bring transparency and create atmosphere of the accountability. Sir, any law requires some time to show its effect, and I believe that the due course of time, the law enacted by the economic reforms will show the commitment of the government to make India a strong economy and a global platform for the investors also. Sir, recently we passed the bankruptcy and insolvency law, and the very recent, the advertisement for the member of the insolvency board by the finance ministry shows that we are not stopped after the passing law. We are working stepwise to achieve the purpose as soon as we can. Every day government is providing its commitment with its work for achieving the goal of becoming a business hub through bringing policies which are apt for globalized time. Sir, the prime focus of the government is to make laws and policy which ensure higher accountability, more transparency, and to making easy access of information and delivering fast services by making best use of the technology. With this objective, we know that the DRTs also faces the shortage of the judges also. So in the present act, we are enhancing the age of the judges. In DRT, that is a 65 year, and DRT, there is an age of 70 year. We also know sometimes the vacancies are not filling because the person is not available. So in the earlier, there was an amendment made in the Airport Authority Act also, that the appellate tribunal, if their person is not there, a similar situated tribunal is there. So the similar situated tribunal judge also we work as an ad hoc in the same tribunal also. So that provision provided in the DRT court also. So our cases not suffer because the judges are not there. For that purpose, we will not suffer in the future also. So sir, in this present act, the pending cases in DRT has been a matter of concern for government. And therefore, government is concerned with the strengthening DRT by every possible way. Shifting workload towards NCLT after implementing the bankruptcy and insolvency code is one of the such step which will reduce the huge work pressure of DRT, because as per insolvency and bankruptcy code, NCLT is adjudicatory authority for the cases related to the non-payment of debt by company and LLP for the default amount notified by the government, and once the application is admitted, there the proceeding in any other court will be stayed for the same time. Sir, there is a time frame is also necessary, because if we are not able to dispose the cases in a time frame manner, especially the financial matter, then it will be the very huge loss for the country also, because investors are not ready. Those who have investing the money, sometimes they feel that system is not with them. So a time frame procedure we are providing by the present amendment also. And sir, I want to say that these amendments made by the government in the SURFACE Act, as well as the amendment moved by the government in the DRT Act, also with the harmonization with the earlier bankruptcy and insolvency law also. Because in the bankruptcy and insolvency code, we provide a one major structure or major institution to for the resolving of our insolvency and all this problem. I would like to conclude with the firm belief that while identifying the loopholes and simplifying legal procedure, making provision to assure accountability, transparency and security of investment, India has taken steps to become a place to become one of the few choices to do business. The aim of ease of doing business is to empower competent people to venture out, encourage them to take risks, and facilitate them to compete with the global market. Further, it will provide employment to people at all levels. Again, I would congratulate the government for attracting investors and multinational and companies and government by providing simple and effective adjudicatory mechanism. It is successfully achieving the dream of Make in India, Startup India, Digital India, Stand Up India, so on and so forth. which is the vision of our Honorable Prime Minister. I congratulate to our Honorable Prime Minister and also to our Honorable Finance Minister for doing this, to achieve this object very fastly and very committedly.
Thank you.